and welcome back to another episode of Parallel Barking.
Woof, woof, woof.
That was...
And that's probably the most cogent thing I'm going to say today.
Yeah,
woof, woof, woof.
There have been a lot of things going on.
A lot of things. We'll talk about some of them in a bit. But we got one thing that probably has slipped past, given all of the other things that are going on. Russia, Ukraine, the large number of random shootings at schools and other places, grocery stores and churches. And we'll get to all of that. But this is something that was sort of overlooked. And that is, it looks like the Supreme Court is now narrowing. And we don't know whether it's significantly narrowing it on constitutional grounds, or narrowing on the basis of federal statutes, but narrowing the right of people who are convicted under state criminal laws to challenge that conviction, not just under the rules of state courts, but also to challenge it in federal court on the basis of what now the new Supreme Court majority says is an overly broad reading of the protections of I guess it's the Sixth Amendment. Caveat, I am not by any means an expert on habeas, and we're not going to talk about the validity of the decision, but although just, sideways. But the case actually raises a set of much more fundamental and interesting issues that we see not just here, and this is why I was very excited about talking about this case. This is, in one sense, it's about habeas and prisoners and conviction. In another sense, this is Roe versus Wade, the Roe versus Wade decision in a new guise.
Right, continued.
It's a federalism case.
Right, it's more dismantling of the Supreme Court's decision-making.
Well, they mantled it, they can dismantle it.
That's why I said dismantling.
No, I said they mantled it to begin with, and now they're dismantling it. And so to some extent, I have very little pity for people who are whining about this now, because they were more than happy to cheer the Supreme Court on in this role when they did exactly the same thing, but with a series of decisions that they liked politically. Now they're using the very same tools that they used to build this castle.
I wasn't alive then. So what? I wasn't alive then.
You weren't alive in 1789 either. I guess that means that you shouldn't vote. Most political writings tend to love to have it one way, but not the other. And this is what's going on here. You choose to politicize the Supreme Court. You choose to invest in them some kind of quasi-legislative and significant constitutional authority, the limits of which remain quite contested. And then, having vested them with all this power, because they did all these good things politically in the view of the people who are now whining, but with respect to which the people who hated it over the last 30, 40, 50, 60, 70 years were whining, but everyone dismissed them because they're just whiny. Well, all of a sudden now the court is using exactly the same power to undo what their predecessors, who are no longer alive, what their predecessors did 70 years ago. And now everyone is going on about, oh my God, this shows that there's some kind of institutional horror show going on, when in fact, what you're doing is merely reaping what has been sown in this country over the last 60, 70, 80, 90 years. And that is to have a highly political court, and the product of extraordinary political laziness in which you invested the court because it suited you. You invested the court with extraordinary quasi-constitutional authority, not interpretive, but regulatory, to some extent, you then took decisions and treated them as if they were effectively constitutional amendments,
Right.
not just constitutional glosses. And now that you've built that and you've pounded that on the heads of your opponents, now all of a sudden your opponents are winning, and you go, "Oh, no, 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 I'm sorry,
oops,
that's not what I meant. That's not what I meant."
What I'm worried about, of course, is we're losing the checks and balances that
Well,
were originally put in place for
no,
instances
no,
like
no.
this.
Nope, nope, no, we're going back. I mean, what the opposition would argue is no, 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 we're going back to the reinstitution of the way in which the checks and balances were envisioned in 1790, not the way you all were envisioning this. The United States of America was not formed in 1937.
All right,
It's formed
cool.
in
All right, 1790, we had slaves, so that doesn't mean everything in 1790 was great. But what I'm saying is,
We're not talking about slavery. We're talking about institutional development,
institutional,
which, unlike slavery,
whatever,
has not been constitutionally amended.
Just because it was like that in the 1790s doesn't mean it was perfect.
Oh, good. So that the document is not worth the paper it's printed on.
I'm saying we always need to
do what?
Look at,
To
review,
rewrite the document to suit the times. That's cool. As a semiotician, I absolutely agree with you. Words are meaningless until every generation invests it with whatever meaning they want. But if that's the case, you're no longer you are now conceding that the document has no history.
And I'm
no
assuming you're talking
foundation.
about the Constitution right now.
Yeah. I'm talking about the Constitution, right? And now we're square. We're now square, and that's fabulous. So I'm glad you said that. We're now square into, and what we were doing effectively was mimicking the arguments that you're seeing at a much higher level of discourse, quote unquote, playing out in the Supreme Court and to some extent within policy circles. And that is what we're fighting over the words. And we're fighting over words that have been placed in a document. We're fighting over the meaning of that document. And we're fighting over not only who gets to say what that document means, right? But we also are arguing about to what extent can you invest those words to a large extent written in 1789, to a significant extent, and this is a 13th, 14th, and 15th Amendment, and the amendments that came after 1860, after the Civil War, right? So two beginnings of this republic, but both of them a fairly long time ago, right? Who gets to invest those words with meaning, and how are there limits to the way in which you can play with the meaning of words? The traditionalists, and you saw that, and used Roe and then used this case. And by the way, this is the Shin versus Berry case, I guess.
Yeah, we forgot to mention this was about a case in which Barry Jones in 1995 was convicted of murdering Rachel Gray, who was his girlfriend's 4-year-old daughter, and he was sentenced to die. But since then,
there are actually two cases, and another case that is a companion case. But yeah, that we can use that as a principal case.
Right.
So he was sentenced to death. But the case went all the way up on appeal.
But
appeals were rejected, and then they instituted post-conviction relief proceedings at the state court.
Right.
Those were also exhausted unsuccessfully. And then after they finished their state post-conviction hearings, this is quote unquote habeas, they then went and they used federal statutes and a long and fairly well-developed, although very contentious line of Supreme Court cases to then initiate an additional set of post-conviction challenges in federal court. In this case, on the basis of the what was it? That they didn't have competent counsel, ineffective assistance of counsel, right? Which has constitutional dimensions, not just at the level of the trial itself, but ineffective assistance of counsel in the post-conviction
Right.
stream of hearings.
Basically
right?
throughout,
but different sets of counsel, and that therefore two things had to happen. One, that they have a right to be in federal court, and two, because the nature of the ineffectiveness of counsel touched on the quality and character of the evidence presented and the quality and character of its interpretation, then the federal courts, sitting now effectively for the third time or the second and a half time,
whatever
or the second time in post-conviction hearings, would be able to either have hearings, that was one case, or to consider additional evidence or additional evidentiary tweaks that were not raised,
right, that were left
either
out.
during trial or during the state post-conviction trial. So effectively, they got now 3 shots to bring in evidence. You failed to do it at the original trial. You failed to do it in the state post-conviction, and now you're getting a shot to do it in the federal court. What the majority said, well, let me do the dissent first. What the dissent said was, this makes perfect sense. Why does this make perfect sense? Because the whole purpose for this second round of post-conviction appeal was based on ineffectiveness of counsel, and the nature of that ineffectiveness of counsel was evidenced by their inability to either gather this evidence that was there and then present it, or to present it correctly, and that therefore this isn't a third shot at the apple, given the nature of the incompetence. This is a first shot at the apple, and that right, and they should. And since this is Sotomayor in dissent, since the purpose of the criminal law is to ensure that we wrongfully convict and punish as few people as possible, then, and given Congress's willingness to permit a procedure and the court's willingness through its precedent to expand it, then it makes perfect sense to give these guys another shot at this. They may win, they may lose, we haven't gotten there yet, but they ought to have a shot because that's what we value. Boom, we go back, and this picks up where we left off before we went back to talk about the cases. The majority says, no, that's not how it works. The purpose of federal involvement has to be secondary, and it has to be extraordinary because of the nature of the federal system in which, or through which, or on which this republic was founded. And so for them, the idea is that what is the most important thing is the protection of the integrity of the sovereign authority of the state as the principle.
Oh, to screw up. Okay, cool.
No, the federal courts can screw up too, because in fact, the federal courts can get it wrong too. And you could do this ad infinitum. Wait.
If you could only see my facial reactions, people.
I see your face. And in fact, the very federal courts that are now holier than thou, not 20 years ago, when the International Court of Justice came in and said, American federal courts, you screwed up, and therefore I think you ought to get now yet another chance. The American federal court said, oh, I don't think so.
Yeah.
Because we have to protect the integrity of the federal sovereignty as against the international. So no, that's a little bit hypocritical, but yes, your heart's in the right place, right? So Sotomayor's heart is in the right place. So what you're looking at is the individual, and you're looking at the notion is that the state ought to be very cautious. When it looks to convict, then her argument actually is quite plausible. When you look at it from the perspective of the Avena case, this is like the case 20 years ago, the International Court of Justice, where the issue was federal sovereignty, as well as in that case, it was the sovereign authority of the criminal justice system in the state of Texas. When you look at it 20 years later in this case, right? The question is not the protection of federal sovereignty, but the protection of state sovereignty and state sovereign rights with respect to an area that this majority believes was not consigned to the federal government. Now,
But
there's
what
a lot of
constitutional right was crossed for the International Appellate Court?
they failed to, in that case, that they failed to allow foreigners that were arrested on charges to reach out to counsel. In that case, it was there had been an earlier case with a Paraguayan. In this case, it was a Mexican national who'd been convicted of a really horrific crime, and the authorities did not allow did not notify Mexican counsel, and so it went off in that direction. This one is very different, but what we're talking about is not the conviction itself or the heart of the habeas hearing. What we're talking about are the structural issues right around this. And here, the big structural issue is: are you going to look at the criminal defendant? Are you going to frame the nature and expression of the federal role in the protection and interpretation of federal constitutional rights around that individual? Or, we haven't gotten to this yet, are we going to do what we did in Roe and say, no, look, this is a federal republic. There are only some things that have been confined to the federal government. We have to look at that narrowly. And in this case, they say that the criminal law, and this is why I want to develop this, because there's a really interesting little ramification here that is going to come and bite people in all kinds of places. But they said, look, criminal law is at the very heart of the essence of the power of the state, the residual power of the state that was left to the states in 1790. Agree or not as you like, this is what they're saying.
Yeah, I get it.
Right? It's plausible, right? Therefore, our primary obligation is not to protect the individuals within this thing, as Justice Sotomayor does, but our principal obligations on this court is to protect the integrity of the system itself. And in this case, the system requires us to protect the sovereign authority of the state of Arizona, in this case, as it was Texas.
Oh my God, it's like HR in corporate America.
Well, but to protect it. And in this case, there's no question, right, that the person had an opportunity to get counsel at trial. He had an opportunity to change it. He had an opportunity to go through post-conviction hearings. And, you know, unfortunately, they didn't say unfortunately, that's what is provided for in the state that is constitutionally adequate. According, now, again, all of these things are contestable, but according to the majority, they got everything procedurally that they deserve. And it is beyond the authority of the federal courts, either on the basis of the Constitution or on a very strained reading of the federal statute.
Yeah, this just seems like a very narrow.
It's no, that's the opposite, but that's the point. This is Roe versus Wade, the Dobbs case again, overturning Roe. The idea here is that at the very forefront of all of their jurisprudence has to be a significant sensitivity to and protection of the prerogatives of states as against.
Yeah, it's just very strict to the language of.
But plausible.
Okay,
but again,
but that doesn't mean it's just black and white. It's just black and white. There's no room for gray.
2 generations were more than happy to thrust the Supreme Court into this utterly political role. Well, congratulations. Now you're in a political role. You're going to make decisions and you're going to really annoy people, especially when the decisions are plausible. But here's the kicker. Wait, I know we're getting close to the end. Here's the kicker. So they start by saying, look, the heart of federal power, the heart of state power is criminal law in a sense, right? If that's the case, and you had asked me before we went on the air, you said, well, what's the end game? Right. And and here, right, the end game is to restore states to their sovereign majesty. And in this case,
that's what it seems like. I'm getting that from this.
They planted this seed. They planted this hysterical seed. All right. So here's the seed they planted. If in fact the core of state sovereignty is the criminal law, then to what extent, if at all, does the federal government have any power to criminalize any activity.
Oh my goodness!
Ah, boom.
Boom! Drop the mic!
This is the mic drop part, right? Boom, I'm done. Now,
Yeah,
clearly,
so also the Supreme Court's opinion doesn't matter. Like I said in our first pod about Roe versus Wade, again.
well, no, it matters very much. But like you said, they're causing the problem here is on multiple fronts. On the one hand, you've got the actual problem in the case, and that is where do you center or decenter the individual in the context of post-conviction hearing rules in a country, a federation of divided power.
This should piss off.
But the second thing you're looking at is how do you determine the consequences of divided power in the first place? And this court is taking that the position that in fact you should in fact not broaden federal but broaden state residual authority in the absence of the federal government. And at the third point, it then suggests two things. I mentioned one. One is, whoa, maybe given the reading, a broad reading of this opinion, maybe the federal government is overextending its authority to criminalize matters. But then the second question is, to what extent could this be solved if Congress explicitly created a statute in which it said, we have interpreted the Sixth Amendment of the Constitution to permit prisoners or convicted people from state proceedings to come to federal courts if they allege a violation of their federal constitutional rights, which we deem to include incompetent counsel during state post-conviction hearings. And in the process, we hereby give them the right to raise issues that as a result of the incompetence, they were not able to raise either in trial or in the post-conviction hearings. Now,
okay, well, that's how it's supposed to work.
Well, but the Congress hasn't done that.
Yes, right? You're right.
All of this, so we're building these elaborate houses of cards on the basis of judicial opinions. And so that's my second point. Point number one, whoa, maybe the federal government has a much more limited, we've now opened the possibility that there'll be litigation on the extent of federal criminal law. And then the second one is we've opened up yet another interesting question about whether in fact Congress can solve this if they wrote a statute that someone could actually read and with a direction that is fairly clear.
I mean, the answer is yes, they could, but will they is the real question.
Right, but that's politics. That's politics. Right. And so you've got a very, very interesting state of affairs here. And yes, I can tell that in this opinion, you would have signed on to Sotomayor's dissent.
Well, okay. Yes, I would have, but it's, and I understand both. I get where Justice Thomas is coming from, but
it's awfully mean. And you could ask yourself, was there another way to do it?
Yes, there absolutely could have been another way to do it. It just seems really careless.
But the one institution that no one is getting mad at and that they should be getting mad at. Thank you. Yes.
Like, what the hell are you doing? Why are you just sitting there watching this?
Because they've been able to do it because the court has been willing to step in over the last 80 years to solve Congress's own incompetence or failure to act, or to step in, especially where Congress didn't have the political will to do something that everyone kind of thought that had to be done. All right, so that's all I got on this one.
Yeah.
What else you got? I know it's
time
to wrap this up.
That's what I got. I'm pissed. Yeah. I think
plausible, but that's good to be pissed. It's politics. So at this point, the question is, do you go back to the states the way we did with Roe? Do you go to the federal government the way you could do with the end of Roe as well and this? And then what kind of litigation comes after that?
Yeah, I mean, I guess, yeah, that's my next question. What kind of, so I guess the majority opinion is now,
well, it's worth as much as Justice Alito told us that majority opinions are worth after the Dobbs case, which may mean not very much. If a subsequent court determines, you apply that 5-factor rule that it was wrong from the beginning, it's causing all this harm, blah, blah, blah. So who knows what it'll be worth. Anyway, last words, my love. Mine are woof, woof.
Mine are, yeah, I guess that's it.
All right. Until next time then.
Until next time. Thanks everybody for listening, and we'll have some more goodies for you
Woof,
on the
woof.
next episode. Bark, bark.
Woof, woof.